To enumerate what are those crimes against persons under Title 8 na. And they are 1. Parasite. 2nd, murder. 3rd, homicide. 4th, death caused in a tumultuous affray. 5th, physical injuries inflicted in a tumultuous affray. 6th, giving assistance to suicide. 7th, discharge of firearms. 8th, infanticide. 9th, intentional abortion. 10th, unintentional abortion. Then 11th, abortion practiced by woman herself or by her parent. 12th, abortion practiced by a physician or midwife and dispensing of abortives. Atong topic tonight is only up to this 12, no? And then we go forward. Number 13 is jewel. Tama man yung jewel karon sa una. Ang jewel mo na uso sa una, no? Pagkuhan wala pa kayo bawal ang magdandalang armas sa una karon, bawal naman. Nya tapos ikuha na sila kanang sa ato Pilipinas, nagkuha na sila og kanang inspiration sa mga western movies sa US. Sagaran mga western movies, mga jewel mga na. Tumapod ni, but then again, beforehand sa time pa sa mga Amerikano diri sa Pilipinas, nananing put up na ning criminality on jewel, no? Article 260. Challenging to a jewel, mutilation, serious physical injuries, administering injurious substances or beverages, less serious physical injuries, slight physical injuries, and maltreatment. And the last one is rape. So those are the enumerations on crimes against persons. Let's go directly to section 1, parricide, murder, homicide, and article 246, parricide. In talking about parricide, siyempre, father, di ba? Parasite, father. Mo gina inyong nasa una. But encompassing na siya nga, relativity. Parasite, any person who shall kill his father, mother, or child. So it could be the son or the daughter killing his father and mother. Or the father or mother killing his child. Whether legitimate or illegitimate, or any of his ascendants. Including sa ascendants. Father, mother, tapos grandparents, mga lulu-lula, lulu sa tawak, lulu sa tuhod, lulu sa muna ang any ascendants. Descendants is anak, apo sa tuhod, apo sa lapalapa, ang pababa ng pababa. Or his spouse, no? Imuhang asawa, imong bana. Muna ang relationship in the crime of parricide. So, any person nga included aning relationship, imong mama, imong papa, imong anak, imong asawa, imong bana, lulu, lula, anak, apo. Parricide ang tawag ana. So, what are the elements of parricide? The elements are that number one, a person is killed, that the deceased is killed by the accused, that the deceased is the father, mother, or child, whether legitimate or illegitimate, or a legitimate other ascendant or other descendant, or the legitimate spouse of the accused. So, mga legitimate na rin po sa kasagaran, no? But except there is a child, legitimate, pwede illegitimate, pwede illegitimate. But while the other relatives, legitimate puro. So, legitimate mo lulug-lula, apo, legitimate ni mong apo, diba? So, kung ang imong apo is illegitimate, I think dili na sa mo cover, no? Ang imong anak, kung legitimate or illegitimate, yung imong patay nimo, so parricide na siya. But then, ang imong anak nga, imong apo nga anak sa imong legitimate child, mapatay nimo, parricide. Pero kung imong apo anak sa illegitimate child nimo, I think it's no longer included. Mora man ang gi-appeal diri sa kwan, aning legitimate or illegitimate. Any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or any of his descendants or spouse shall be guilty of parricide and shall be punished by the penalty of reclusion perpetua to death. Ano ang mga elements dere? Or a legitimate other ascendant or other descendant, or the legitimate spouse of the accused. So kung ang imong spouse legitimate, dili na ma-charge of parricide. So the essential element there is the relationship of the offender with the victim. Diya sa crime of parricide. The ascendants and descendants referred to in this article excludes parents and children. Wala ilabot kay giapil naman ang parents o children naman dire sa main. Katong any of his ascendants or descendants or spouse, lahat na to siya. Exclusive na to siya. Okay, the other ascendants or descendant must be legitimate. Who kills an illegitimate grandfather or an illegitimate grandson is not guilty of parricide, but of simple homicide or murder as the case may be. The term illegitimate embraces all children born out of wedlock. Thus, adulterine, incestuous, and sacrilegious children are included under the term illegitimate. So the father or mother mother or child may be legitimate or illegitimate. Clear na siya, no? Mother, father, side. Pero other descendants, other ascendants, dili gyud pwedeng illegitimate ato. The child killed by his parents shall not be less than 3 days old. So, katong nang patayan niya nga child should not be less than 3 days old. Ganun. Kung less than 3 days old siya, ang crime na iyang na-commit is no longer parricide, kundi infanticide na siya. This is another article, no? Article 255. Okay. The spouse must be legitimate. Katula illegitimate, ang dili pwede illegitimate katong other ascendants o other descendants. While the rest are pwede siya pati pa ning legitimate yun siyang spouse, no? Legitimate spouse, legitimate ang other ascendants, legitimate other descendants, legitimate father, mother, child, pwede legitimate ang ilahang relationship. So unsa kung mapatay nimo ang illegitimate child nimo, illegitimate nimo ang apo, unsay crime na commit, dili na siya parricide, 3 days old man to, infanticide. So ang imong apo nga halimbawa mga 2 years old, apo nimo dapat legitimate siya. So kung papatay nimo imong apo nga 2 years old, legitimate siyang apo, parricide siya. What if ang imong apo is illegitimate, meaning ang imong child is illegitimate, so apo yang anak of course illegitimate. So kung mapatay nimo ang apo nimo illegitimate, ingon ang balaod, dili na siya parricide. Unsa naman di ay siya crime gyapon siya, of course, pero dili siya parricide. Kung unsa siya nga crime. That's correct. Homicide. Parricide can be committed through reckless imprudence, can also be committed by mistake, no? Husband who killed his wife was ordered to indemnify his wife's ears 50,000 pesos. But in the case where the natural father killed his child, no indemnity was imposed, considering that the accused as the father is the presumptive heir of the deceased. The liability of stranger cooperating in parricide. A stranger who cooperates and takes part in the commission of the crime of parricide is not guilty of parricide but only homicide or murder, as the case may be. So, wala man sila relationship good, no? Even if they are principal by direct participation or principal by inducement, atong laing tao who commits the crime of parricide, dili siya guilty of parricide, kung dili guilty lang siya of homicide or murder. Nga naman, wala man siya relation dito sa namatay. Article 247, kani, very interesting article. Death or physical injuries inflicted under exceptional circumstances. Any legally married person who having surprised his spouse in the act of committing sexual intercourse, nakit-anjot with another person, shall kill any of them or both of them in the act or immediately thereafter, or shall inflict upon them any serious physical injury, shall suffer the penalty of dischero. Napatay na niya, no? Pero ang penalty is dili siya imprisonment kundi dischero. That's why it's called, gititle na siya of physical or death or physical injuries inflicted under exceptional circumstances. Well, anybody, no? Confronted with the situation when bungat mo sa kwarto, naay mo ang spouse dito, gipatungan or nagpatong. So, alam namin, ay, ayusan ninyo, ay, maana na yung reaksyon, di ba? Dili, no? Ana ba reaksyon sa uban? Admit na nila ang realidad nga, we are all for one another, love each other na lang daw. Pero kung ikaw, spouse you ka, pwede na, mapatayin mo sila because ibuhatin mo na in immediate reaction of what you have seen, no? Immediate reaction, what ang kagpali mo, na mo na exempting circumstance dira. So, pagbuhat ni mo ato, whereas kung hawa ka, tapos pila ka adlaw, muni-muni ka, saka ni mong ipatay, dili na to siya dili na to siya maka-over diri sa death under exempting circumstances. Ato lang, immediate reaction, mao gyud na dapat ang imong penalty, dischero lang. If he shall inflict upon them physical injuries of any kind, he shall be exempt from punishment. Physical injuries lang, exempt na from punishment na siya. Pero kung napatay gyud niya, mato ang dischero. This rule shall be applicable under the same circumstances to parents with respect to their daughters under 18 years of age and their seducer while the daughters are living with their parents. Any person who shall promote or facilitate the prostitution of his wife or daughter or shall otherwise have consented to the infidelity of the other spouse shall not be entitled to the benefits of this article. So see, ano yung article ka-benefit akusado ani? I mean, except kanilang sa last paragraph nga iyang gi-encourage, gi-promote niya ang prostitution or otherwise consented to the infidelity pasaba so ban nga mga nebala na to ang uban gid-dramatize pa kay nang istorya nila nga kapito sa panahon wala na sila makaon, tanan sila nag-prostitution na lang sila, and they consented to prostitute each other's body para lang maka-income, para lang mabuhi nila ilang mga sarili. It may not be a good idea para sa ila at that point of time, sa ilang wala nilang mabuhat, otherwise matay sila, nakanganga ilang baba wala kinakaon. Very pity. So, that's Article 247. Dischero ang yang penalty. So mga requisito sa application sa 247 that a legally married person, take note ang pinaka-central na element ani is that the spouses are married to each other, legally married, so legitimate ni sila married. And in the case of daughter, legitimate daughter, surprises his spouse or his daughter, the latter under 18 years of age, and living with him in the act of committing sexual intercourse with another person, that he or she kills any or both of them or inflicts upon any or both of them any serious physical injuries in the act or immediately thereafter. May nakita nimo pero wala gyud nimo dayon na aktuhan, gigukod nimo mo na immediately thereafter. Dili pwede nang one day after sa kapalin mo gipatay, dili na lahi na siya ang istorya. That he has not promoted or facilitated the prostitution of his wife or daughter, that he or she has not consented to the infidelity of the other spouse. This article does not define a felony for if the killing of or in the inflicting of serious physical injuries on the spouse and or paramour is done under the circumstances mentioned in this article. The accused shall be sentenced to dischero instead of the severe penalty for parricide, homicide, or serious physical injuries provided in Articles 246, 249, or 263. The wife who kills or inflicts serious physical injuries on her husband and or his concubine under the circumstances mentioned in Article 247 is entitled to the benefit of the said article. So dili lang ang lalaki lang ang pwede maka-benefit ani, pati po na babae. It works both ways. So address na to kung parents ba legitimate. This article does not seem to require it. It requires only that the daughter be under 18 years old and that she is living with her parents. It doesn't matter kung legitimate or illegitimate ang daughter. If those circumstances concur and her parent surprises her on the act of sexual intercourse with a man and kills or inflicts serious physical injuries on her or both of them, so Article 247 applies. Does this article apply even if the daughter is married? It would seem that although the law does not use the word unmarried in relation to daughter, this article applies only when the daughter is single, because while under 18 years old and single, she is under parental authority, and if she is married, her husband alone can claim the benefits of Article 247. And besides, when the person is under 18 years of age, he cannot be married altogether, no? Muna, karang mga panahon na, sa una, pwede ba minyo under 18 years old. But, kung under 18 years pa ang daughter, presupposes na single jud siya, hindi siya married. So, kung married na siya, accordingly, only the husband can claim the benefits of Article 247. So na-surprise surprising the spouse or young daughter the act of sexual intercourse is indispensable requisite. Ako po tayo din nga nang sila man ang dapat ma-surprise, dapat ikaw po ma-surprise, no? So kung dili ka ma-surprise, dapat mga akusado ang ma-surprise ani. Pasabot nag-andama dahil ni mo, nakabalo nakadaan, no? So the person claiming the benefits of Article 247 must surprise his spouse or daughter under 18 years of old and living with him in the act of committing sexual intercourse with another person. If he has not surprised them in the act, Article 247 will not apply if he kills or inflicts serious physical injuries on one or both of them. Therefore, a husband who upon arriving home one night and seeing a man jump out of the window killed his wife, who was begging him to pardon her, is guilty of parricide, and the penalty to be imposed is reclusion perpetua to death, not dischero as prescribed in this article. Wala man na surprise, so mo nang pasabot, surprise pasabot, mo-surprise din mo sila pasabot na quote on the act yun siya, no? Ano na ang inherent na message dira. Ay kung wala nimo sa na quote in the act, nakita na nimo to pa sa ning example, kita nimo nga niambak sa bintana. Kita ko katong post sa Facebook ba. Kita niyo to? Niambak sa bintana, gikan sa third floor ito bintana. Hulog siya. lapos siya sa scene diya sa sa baba sa second floor scene dito, lagpak dito sa ground jud. And then pagbangon niya, way serena lalaki. Kita niyo to sa Facebook. Yes, Jolly. Ang hubo naaktuhan nimo. Atong basahon ning kuan ha. Atong basahon na and the act of sexual intercourse na hubo. Basta to balik ang article, no. In the act of committing, having surprised his spouse in the act of committing sexual intercourse with another person. So kung naghubo lang, dili siya pwede mapasok, no, kay actual man jud ang imong dapat makit-ani mo. In the act of sexual intercourse man jud ang nakasabot sa balaod. So that's kanay answer na. Does sexual intercourse include preparatory acts? Suppose a married woman and her paramour enter a room alone, then and thereafter undress themselves, the hubo, perform mutual acts of the character of lasciviousness, all in prelude to the carnal act, and there the offended husband who saw all these things killed one or both of them. Is he entitled to the benefits of Article 247? The majority of the justices of the Supreme Court in the case of People versus Gonzales 69, Philippines 66 believe that there must be actual sexual intercourse. But Justice Laurel, in his dissenting opinion, asks, must the offended husband look on the meantime and wait until the very physical act of coition takes place? This interpretation is far from being rational and certainly does violence to the reason and purpose of the law. So accordingly, dili siya pwede. Kung imang question, kung naghubo lang, dili pwede. Dapat nagi sexual intercourse. Although, katuwa decision in that particular case of People versus Gonzales, na isa ka dissenting opinion ato. Pero as they say, majority rules man. So katugya po majority rules ang nag-prevail na kung maghubo lang, preparatory pa lang, nag-andam pa lang ganun sila bago magkinusukay. Dili siya makover ani. The killing or inflicting of serious physical injuries must be in the act of sexual intercourse or immediately thereafter. Kanang immediately thereafter. Katong preparatory dito siya makover, no? Pero immediately thereafter, human na. When a person surprises his spouse or young daughter while having sexual intercourse with another person, it is necessary for the application of Article 247 that he killed or inflicted serious physical injuries on any or both of them while they were in the act of sexual intercourse, or if not, because they were able to run away immediately after surprising them in the act of sexual intercourse. Well, kaning immediately thereafter is the act of killing na ni siya. So, pero naaktuhan yun niya. Na-surprise yun niya, naaktuhan niya, naging siya sexual intercourse. So, immediately thereafter, act of killing na to sila sa mga akusado, sa mga victim. So, what's the meaning sa immediately thereafter? Accused Alano, feeling tired, went to bed, while his wife, Teresa Marcelo, remained at the window looking out, and little while afterward told her husband that she would go down for a moment to the Chinese store nearby, which she did. So, as Teresa Marcelo was slow in returning and her sick child was crying, Horacio Alano left the house to look for her in the Chinese store situated in the corner of Calles, Dakota, and Tennessee, and not finding her there, went to look for her in another Chinese store nearby. With the same result, he therefore started to return home through an alley where he tripped on a wire lying across the way. He then observed as he stopped that among some grass near a clump of thick bamboo, a man was lying upon a woman in a position to hold sexual intercourse with her. But they both hurriedly arose from the ground, startled by the noise made by the defendant. In stumbling, Alano at once recognized the woman as his wife for whom he was looking, and the man as Martin Gonzales, who immediately started to run. He was wearing an undershirt and a pair of drawers, which lower garment he held and pulled up as he ran. Enraged by what he had seen, the defendant threw a fun knife he had in his pocket and pursued Martin Gonzales, although he did not succeed in overtaking him. And not knowing where he had fled, he turned to his wife. Then he found his wife Teresa in the act of climbing the stairs. He then stabbed her several times. She died as a result of stabbing by the accused. So the unfaithful wife was not killed by the very place where she was caught, for the reason that The wrong husband preferred first to attack the despoiler of his honor and afterwards the adulterous wife, who succeeded in getting away from the place where she was caught with her paramour. The assault upon the woman must be understood to be a continuation of the act of the wronged husband's pursuit of her paramour, who had the good fortune to escape and immediately get away from the place of the crime. Consequently, although the deceased did not fall dead in the place where she was caught, but in another place nearby, logically it must be understood that the case at bar comes within the provisions of said article. The discovery, the escape, the pursuit, and the killing must all form part of one continuous act. So muna ang immediately thereafter. No? There's another example, just read him. The killing must be the direct byproduct of the accused race. Race byproduct siya eh. The killing of his spouse by the accused must be by reason of having surprised her in the act of sexual intercourse with another person. What is the justification for Article 247? The law, when the circumstances provided by this article are present, considers the spouse or parent as acting in a justified burst of passion. What anjo ka sa panimot, what anjo ka sa may pauna-una na makita nimo ang imong partner nga gipatungan or nipatong. No? Article 248, murder. Okay? Wala pa to sa homicide ha, murder pa lang ni. Any person who not falling within the provision of Article 246, so dili siya parasite, shall kill another, shall be guilty of murder and shall be punished by reclusion perpetua to death if committed with any of the following attendant circumstances. You know, murder is the result of homicide with attendant qualifying circumstances. Mo na siya ang qualifying circumstance ng homicide. Actually ni siya, pero na mga qualifying circumstances nga gi-enumerate diri, mo na siya ni graduate o siya og murder. So dili siya parricide but homicide siya pero with attendant qualifying circumstances. Is qualified, no? Homicide qualified by some circumstances, making it murder at this time. O saan yung mga circumstances nga gina-enumerate diri? Atong basahon ha. Number 1, with treachery. Something treachery, taking advantage of superior strength. Ang treachery, grabe kayong discussion ani sa book 1 baka ng treachery. Diba? If you can recall, taas kayo discussion sa treachery. Ang lipot, God, wala ka bantay. It's actually, pinaka-simplest term sa treachery is kilipot. Parang i-describe niyo, pinaka-simple ng description lang po na is that the person, the victim, he has no opportunity to fight back. Gi-ensure niya nga ang victim will have no opportunity to fight back. Listening the risk of his injury or damage when the victim could have fight back against him, no? Maka-fight pala unta siya, na-risk sa iyang sa iyang person na ma-damage siya o ma-injure. Pero wala man siya ka-fight back. And gi-ensure nila nga din siya ka-fight back. Mano siya treachery, no? Taking advantage of superior strength. Lain po na, no? Kanang superior strength, kanang na mga armed men, daghan mo. With the aid of armed men or employing means to weaken the defense or means or persons to ensure or afford impunity. This is the word I could have stated to you a while ago when we discussed this, impunity. Ano ganing ginabuhat sa akusado with impunity, knowing that no one will dare imprison him, no one will dare complain against him, because if you do so, wala mo problema. So he keep on doing it with impunity. Muna mabot pasabot sa impunity, no? Very tragic na situation nga ang mga powers that be will be killing or injuring another person without them being afraid that somebody will take revenge against them of what they are doing. Muna impunity. They commit here and there crimes without fear that they will be apprehended. Muna siya impunity. Second, in consideration of a price, reward, or promise. So, muna maka-graduate sa murder na siya. Consideration of price, reward, or promise. Third, by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a railroad, fall of an airstrip, by means of motor vehicles, or with the use of any other means involving great waste and ruin. Murder na. On occasion of any of the calamities enumerated in the preceding paragraphs, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or other public calamity, murder na. With evident premeditation, murder na. Yan daman ni mo daan ba? Nakikita sa imo nga nagbayad ka pinuti, tapos afterwards, after 1 hour, napatay to isa ka tao gamit ang imong pinuti. So, magka-testify siya, nagbayad ka, na naging na siya evident premeditation na plano na yun ka, no? Na nakaipat yun. And the sixth, last one, with cruelty by deliberately and inhumanly augmenting the suffering of the victim or outraging or scoffing at his person or corpse. So, muna ang mga qualifying circumstances sa murder. So, define murder. It is the unlawful killing of any person which is not parricide or infanticide, provided that any of the following circumstances is present. So even if makuhanan mo tanan na ano mga qualifying circumstances dira tanan appeal what treachery na consideration of price na inundation na occasion on any calamities, evident premeditation with cruelty. But for as long as ang imong gipatay is imong asawa or imong bana, imong legitimate anak, imong legitimate ang imong mama o papa, ano imong patay, dili siya murder ha, ma-fall siya dito sa parricide, no? Even if considering all the others, pero ang bata ang imong ipatay is less than 3 days old, dili na siya murder, dili po siya parricide, it will now be infanticide, which we will be discussing later. So mo ni ang mga qualifying circumstances nga na murder na siya. So my elements killed, the accused killed him, that the killing was attended by any of the qualifying circumstances mentioned in Article 248. The killing is not parricide or infanticide. So bisag wala intent to kill niya, imo nang gitik-kitik na niyo sa kutsilyo ba. Tapos ako na niyo tapos para lang imong intention is gitikon lang, naduot man, namatay sa kabantay, no? Example 3, if the defendant had not committed the assault in a treacherous manner, he would nevertheless have been guilty of homicide, although he did not intend to kill the deceased. And since the defendant did commit the crime with treachery, he is guilty of murder because of the voluntary presence of qualifying circumstance of treachery. This ruling may be applicable to all the other circumstances in paragraphs 1, 2, 4, 5, and 6 of Article 248. But take note of the qualifying circumstances. So the killing of the victims is qualified with treachery when the shooting was sudden and unexpected and the victims were not in a position to defend themselves. Treachery is present when the shooting of the victim with the carbine is sudden and unexpected to the point of incapacitating the victim to repel or escape it, and where the hands of the victim were raised as ordered by the accused who fired at him without any risk to the accused, treachery is present. So, but to constitute treachery, the means, methods, or forms of attack must be consciously adopted by the offender. The killing of a child of tender years is murder. The killing of a child is murder even if the manner of attack was not shown. The qualifying circumstance of treachery or alevosía exists in the commission of the crime of murder when an adult person illegally attacks a child of tender years and causes his death. Kay murder, kay tender years pagod, no? So, sa unsang fight sa child sa imuha, di gino siya ka atake, gamay lagi kayo tusik sa imuha, no? Na imong patyo na siya, murder, yun kalaban ni mo. Treachery yun na siya. Treachery yun. Taking advantage of superior strength. An attack made by a man with a weapon upon a girl which resulted in her death is murder, because the offender had taken advantage of superior strength. His sex and weapon gave him superiority of strength. With the aid of armed men, if the accused had companions who were armed when he committed the crime, this circumstance is considered present. So, the crime is murder. The armed men must take part in the commission of the crime directly or indirectly, and the accused must avail himself of their aid or rely upon them when the crime is committed. Employing means to weaken the defense. Maro pa ni siya treachery, no? Pero this is another way, no? A person who suddenly throws a clock over the head of his opponent and while in this situation he kills him. Or one who suddenly casts sand or dirt upon the eyes of the victim and then kills him, evidently employs means which weaken the defense. So, na-initial na fighting chance ang victim, pero wala siya, gilabayan o balas, buling taon, saka pa siya gipatay. No? Para sa itong salida, kita mo itong salida, post na ako, nasa alpassion.com. Karaan ng salida actually. He was taunted as the unknown pistolero sa area nila. Western gapon din siya, western na salida ni siya. Pistolero, no? Pag pinaka-uptick siya si Muna. And then sa iyang pinaka mark nga ginahimo nga ngano nakauna siya is pagtanong sa inyong kalaban nila while they are on duel, no? Duel man siya, duel. Do you need to count? Mingon to kalaban. No, triso siya pusil. Patay yung kalaban, ha. Tanong na need to count. No, triso pusil. At namatay na po siya kay basla naman siya pangutana. Do we need to count? Ingon siya, no. Bako na niya realize na naambala siyang ulo. So, moto na matyan niya. So, ano ang means to weaken the defense? No, ako na remember. You need to count. Tapos count ka na. 1, 2, 3. Wala pa minsan. You don't need to count. Bang! Diretso man. Atay na diretso. So, employing means or persons to ensure or afford impunity. When means or persons are employed by the accused who killed the deceased to prevent his being recognized or to secure himself against detection and punishment, he may be held liable for murder. So in consideration of a price, reward, or promise, the person who received the prize or reward or who accepted a promise or prize or reward would not have killed the victim were it not for that prize, reward, or promise. Such person is a principal by direct participation. The one who gave the prize or reward or who made the promise is a principal by induction. When this circumstance is alleged in the information for murder and proved by the prosecution, both are guilty of murder. By means of fire, poison, explosion. When the code declares that homicide committed by means of fire shall be deemed to be murder, it is intended that there should be an actual design to kill and that the use of fire should be purposely adopted as a means to that end. Thus, setting fire to an automobile in the basement of the inhabited house, resulting in the burning of the house, also in the killing of one of its inmates, it's not murder with respect to the death of a person, but only homicide. Treachery and premeditation are inherent in murder by poison. So kung na poison, inherent na treachery, inherent evident premeditation. On the occasion of inundation, shipwreck, or of an earthquake, eruption of a volcano, epidemic, or any other public calamity. So killing a person on occasion of inundation, shipwreck, eruption of a volcano, epidemic, etc., or any other public calamity when taken advantage of by the offender qualifies the crime to murder. With evident premeditation, the circumstance is present and it qualifies the killing of a person to murder when the prosecution proves 1. The time when the offender determined to seek to kill his victim. An act of the offender manifestly indicating that he clung to his determination to kill his victim. And 3rd, sufficient lapse of time, at least 3 hours, between the determination and the execution of the killing. With cruelty, there is cruelty when other injuries or wounds are inflicted deliberately by the offender which are not necessary for the killing of the victim. The victim must be alive when the other injuries or wounds are inflicted. But there is no cruelty when the offender, in inflicting several other wounds on the victim, has only a decided purpose to kill him. Outraging or scoffing at a person or corpse of the victim. A person is found dead with wounds in the back, neck, and other parts of the body. What is the crime committed? Murder. This is either cruelty if the victim was still alive when other wounds were inflicted, or otherwise outraging or scoffing at his corpse. The word outraging means to commit an extremely vicious or deeply insulting act. The word scoffing means to jeer and implies a showing of irreverence. So, illustration of outraging at the corpse of the victim. The act of an accused in having anal intercourse with a woman after killing her is an outrage at her corpse. Weighing the victim's bodies with cement boulder and hubcap and tying their wrists and ankles with nylon cord and wire constitute an outrage of their corpse. The corpse was outraged when it was dismembered with the cutting off of the head and limbs and the opening up of the body to remove the intestines, lungs, and liver. The mere decapitation of the victim's head constitutes outraging of the corpse of the victim. Scooping of the dead. The killer scooped at the dead when the intestines were moved and hung around the neck of the victim's brother as a necklace, and the lungs and liver were facetiously described as pulutan. Kalain ani no. Ayun na, paminaw na nga picture ay. Penalty for murder. So, ipulutan. Gosh. So, penalty for murder should be death. Pero wala may death under our 1987 Constitution. It abolished the death penalty. So, reclusion perpetua is maximum period to death. With the abolition of death penalty, so nahimo na siyang reclusion temporal in its maximum period to reclusion perpetua. 7659 restore the death penalty and increase the penalty for murder to reclusion perpetua to death. In view of RA number 9346, which prohibited the imposition of death penalty, the penalty for murder is now reclusion perpetua. So, daghan mga tag-ubwar aning murder ha, karon na po na po effort ang councilor, mga senador nato like si Bato nga in certain cases na penalty nga murder, death yun dapat ang penalize na. Let's go to homicide. So kung wala tong mga circumstances kanina, homicide na ito, no? Any person who not falling within the provisions of Article 246 shall kill another without the attendance of any of the circumstances enumerated in the next preceding article shall be deemed guilty of homicide and be punished by reclusion temporal. So, klaro, no? Dali lang kayo define ang homicide. Wala on lang mo itong mga qualifying circumstances sa murder. Homicide na siya. Right? Now lang mo pag-define, pag-picture ang homicide. Homicide is the unlawful killing of any person which is neither parricide, murder, nor infanticide. Simple, no? Basta patay. Homicide na siya. Intent to kill must be proved beyond reasonable doubt. So, na-intent to kill gyapon, no? Kung napatay mo siya. The intent to kill being an essential element of frustrated or attempted homicide, said element must be proved by clear and convincing evidence. Such element must be proved with the same degree of certainty as is required of the other elements of the crime. The inference of intent to kill should not be drawn in the absence of circumstances sufficient to prove such intent beyond reasonable doubt. Ano siya? Kaya ang gimension diri is kuan manggod kaning frustrated or attempted homicide manggod siya. So kailangan ay intent to kill yun nga i-prove di mo diri. Was kung namatay na gyud ang tao, di kailangan mo i-prove ang intent to kill kaya namatay na eh. Patay naman. So presumption dira is you intend to kill the person because you cause him to die, no? Pero katong wala namatay, frustrated pa lang siya or attempted, imo na yung tanawon karon kung ang ihang paghimo sa crime ba frustrated or attempted is with intent to kill. Kaya kung wala intent to kill, then dili na siya homicide, dili siya attempted homicide, dili po siya frustrated homicide. The killing must not be justified if the accused killed the deceased in self-defense, defense of a relative, defense of a stranger, or under any of the other justified circumstances. The accused is not liable for homicide or any other crime. At na po ito sa lain nga ay discuss pa natin yung iba na use of unlicensed firearm is an aggravating circumstance in homicide. Absorb na sa una, absorb ba ng unlicensed firearm. Na-absorb siya sa homicide pero aggravating circumstance na lang siya. Pero it doesn't preclude from filing against another that person na nag-possess of unlicensed firearms to be tried under the charge of kanang illegal possession of firearm. So charge po siya homicide, mas charge po siya illegal possession of firearm. Where murder or homicide results from the use of an unlicensed firearm, the crime is no longer qualified illegal possession. But murder or homicide, as the case may be, in such case, the use of a licensed firearm is not considered as a separate crime but shall be appreciated as a mere aggravating circumstance in view of the amendments introduced by Republic Act number 8294, the Presidential Decree number 1866. Separate prosecutions for homicide and illegal possession are no longer in order. Instead, illegal possession of firearms is merely to be taken as an aggravating circumstance in the homicide case. So I stand corrected. Absorbed na siya sa homicide or murder when the killing is attended with unlicensed firearm. Accidental homicide. Accidental homicide is the death of a person brought about by a lawful act performed with proper care and skill. So exempting circumstances yan, no? Hindi siya liable. Thus, in a boxing bout, where the game is freely permitted by law or local ordinance and all the rules of the game have been observed, the resulting death or injuries cannot be deemed felonious since the playing of the game is a lawful act. But if the rules have been violated as a foul blow, the death resulted the crime would be homicide through negligence. And if the foul blow is intended for the purpose of killing the opponent, the crime of intentional homicide is committed. Corpus delicti in crime against person. Corpus delicti means the body of the crime, corpus delicti. So in modern sense of the term means the actual commission of a crime charge. Corpus delicti means that crime was actually perpetrated and does not refer to the body of the murdered person. So, ano ang meaning sa corpus delicti, ha? The crime actually perpetrated, not necessarily the body of the murdered person. Because tapoy corpus delicti sa kung mangawat ka, doesn't necessarily mean na kung nakita na imong gikawat mo na ang corpus delicti. The act of committing the crime of theft is a corpus delicti in itself. In all crimes against persons in which the death of the victim is an element of the offense, there must be satisfactory evidence of the fact of death and the identity of the victim. Thus, when the body of the supposed victim who was unknown could not be located in the bank of the river, the place indicated by the witness, and there was a possibility that the victim might have been burned away by the current and might have survived, the fact of death is not sufficiently established. But if the victim is known and could not have survived because the evidence shows that his arms and legs had been tied with a rope and thereafter he had been stuck on the head with a piece of wood before he was thrown into the sea, even if his body was never found, the corpus delicti is established. You see the demonstration of what corpus delicti is, no? Not necessarily the body of the murdered person. 250. Penalty for frustrated parricide, murder, or homicide. The courts, in view of the facts of the case, may impose upon the person guilty of the frustrated crime or parricide, murder, or homicide, define and penalize in the preceding articles a penalty lower by 1 degree than that which should be imposed under the provisions of Article 50. The courts, considering the facts of the case, may likewise reduce by 1 degree the penalty which under Article 51 should be imposed for an attempt to commit any of such crime. So, kabala naman, lower ang frustrated parricide, murder, or homicide, lower, no? Mas lower by 1 degree. Kung attempted parricide, attempted murder, attempted homicide, lower by 2 degrees. Another 1 degree, no? Article 251, death caused in a tumultuous affray. So, may tumultuous. Tumultuous na siya mga kabibo, mga chaos, no? Chaotic act. So, mga tumultuous affray. So, may kagubot niya sa daghang tao, naggubot. Ya, tapos suddenly, pagka wala na ang gubot na inhabilin, blagta, patay. O, kinsa man iwang basulon ana. Kinsa man ang pwede nimo pinpoint mo na patay ang tao sa kadaghan nila, no? So let's see kung sa ingon diri sa Article 251. Death caused in a tumultuous affray while several persons not composing groups organized for the common purpose of assaulting and attacking each other reciprocally. So ang inkwentro, baka grupo, no? Quarrel and assault each other in a confused and tumultuous manner, And in the course of the affray, someone is killed, and it cannot be ascertained who actually killed the deceased, but a person or persons who inflicted serious physical injuries can be identified. Such person or person shall be punished by prisión mayor. If it cannot be determined who inflicted the serious physical injuries on the deceased, the penalty of prisión provisional, its medium and maximum period, shall be imposed upon all those who shall have used violence upon the person of the victim. So katong patara-taraan nito, wala maghimo, wala mong hit sa victim, wala to sila ilabot, no? So again, ang primero, ang saka atong klaro ay graduate nato ang liable primero principally katong naka-cause of serious physical injury, no? Wala makita ang isa naka-cause of serious physical injury atong mga tao nga nag-apil-apil sa pagkilabot atong tawhana. So katong apil-apil sila, lesser lang po na ilang penalty. Prison correctional lang siya in its medium and maximum periods. Tumultuous affray exists when at least 4 persons took part. No? The word several in the phrase when, while several persons in Article 251 means more than 2 but not very many. The word tumultuous, as used in Article 153, means that the disturbance is caused by more than 3 persons who are armed or are provided with means of violence. So, tumultuous ng 4 persons, yun siya 4 or more, no? More than 3 persons who are armed or provided with means of violence. That's what tumultuous is. And there are 2 identified groups of men who assaulted each other, then there is no tumultuous affray. 2 identified groups of men who assaulted each other. So, dili siya tumultuous affray, no? Two laborers who wounded, ang kaso, A assisted by some laborers was gathering tobacco. Then they heard 2 sounds of horn, and later on the eastern side of the land they discerned more than 13 men coming towards them. When these men came, they surrounded and attacked them. 2 laborers were wounded. When they saw the 2 laborers fall on the ground, one of them sounded the horn and his companions withdrew. One of the laborers later died. There was no confusion in the aggression or the defense. The aggressors helped one another to inflict upon the deceased the fatal blow. The quarrel here was between 2 well-known groups of men. So, klaro kayo kung kinsang kasala, no? Ay katong tumultos manggod, di maklaro. Even katong kauban nila, apil pa sa i-charge sa crime, no? O sa tumultos affray. The crime committed is not death caused in a tumultuous affray. The crime of homicide was committed in view of the death of one of the 2 laborers. The accused and their companions were united in their common purpose to attack, as is shown by the circumstances that they rallied together under the signal of 2 sounds of the horn in order to commence the aggression, and they withdrew from the field also under the signal of 1 sound of the horn. There is no crime of death in a tumultuous affray if the quarrel is between 2 well-known groups. There are 2 distinct groups in a fight between scouts and civilians, or in a fight between the faction of the deceased and that of one of the accused. In both cases, the accused were convicted of homicide under Article 249, not under Article 251. When there was confusion in the fight and the person who inflicted the wounds could not be identified, the crime is death caused in a tumultuous affray. Physical injuries inflicted in a tumultuous affray. When a tumultuous affray, as referred to in the preceding article, only serious physical injuries are inflicted upon the participants thereof, and the person responsible therefore cannot be identified. All those who appear to have used violence upon the person of the offended party shall suffer the penalty of next lower in degree than that provided for the physical injuries so inflicted. When the physical injuries inflicted are of a less serious nature and the person responsible therefore cannot be identified, all those who appear to have used any violence upon the person of the offended party shall be punished by arresto mayor from 5 to 15 days. Pare-pareha rin siya sa katong previous article no explanation. Pero kato sa previous article man gud, damang namatay. Kani physical injuries na rin siya. Giving assistance to suicide. Any person who shall assist another to commit suicide shall suffer the penalty of prison mayor if such person lends his assistance to another to the extent of doing the killing himself. Shall suffer the penalty of reclusion temporal. However, if the suicide is not consummated, the penalty of arresto mayor, its medium and maximum period shall be imposed. So, pwede ako ha, kung naay mga friends ninyo nga, tabangin ko ba, suicide ko, ayaw jud, o apil dira. Tabangin lang siya, tambag, ayaw dayon na. Nung ka apil ka, provide, so, narang hilo, narang konsilyo, narang konsilyo, basi gusto ka. Wow po ganun maghatag assistance to suicide, no? Imagine mo na, mo friend, kay gusto na mo siya, kuhan ka siya, sympathize ka sa iya, tagaan mo siya, assistance, ganyan lang, pagpakamatayin lang, sis, tabangan taka. Ngayon na paminaw, no? Discharge of firearms, any person who shall shoot at another with any firearm shall suffer the penalty of prison correctional in its minimum and medium periods, unless the facts of the case are such that the act can be held to constitute frustrated or attempted parricide, murder, homicide, or any other crime for which a higher penalty is prescribed by any of the articles of this code. So, dili maklaro ka din ang intention nimo. Basta gipusil lang nimo siya, wala kay klaro sa intention, then the act of discharging the firearm itself is punishable under this article. Okay, infanticide and abortion. Infanticide, the penalty provided for Article 246 for murder and Article 248 shall be imposed upon any person who shall kill any child less than 3 days of age. If the crime penalized in the article be committed by the mother of a child for the purpose of concealing her dishonor, she shall suffer the penalty of prison mayor in its medium and maximum period, and if said crime is committed for the same purpose by the maternal grandparents or either of them, the penalty shall be reclusion temporal. So, mo ang infanticide, it's less than 3 days old ang bata na matay. The killer, whether the killer is the parent or grandparent or any other relative of child or a stranger. Isa pa stranger, infanticide, sa mo ang principal na element niya, less than 3 days old ang bata. So, infanticide na ang tawag. And infanticide to commit, to conceal dishonor, katong mga dalagang ina. So, munang usual din na ginabuhat, no? Murag ka ng graduate na siya, magulang na siya gamay sa abortion. But it's not abortion, kaya tao naman. Itong abortion, wap man ito na tao. Abortion will be discussed in the next section. 256, intentional abortion. Any person who shall intentionally cause an abortion shall suffer the penalty of reclusion temporal if he shall use any violence upon a person or pregnant woman. The penalty of prison mayor if without using violence shall act without the consent of the woman. The penalty of prison correctional is medium and maximum periods if the woman shall have consented. So, abortion defined: willful killing of fetus in the uterus or the violent expulsion of fetus from maternal womb which results in the death of the fetus. Just jive it with the next preceding article. I-connect nimo siya sa intentional abortion, and then the other one 561 258 abortion practiced by a woman herself, and the other one is 259 abortion practiced by a physician or midwife or dispensing of abortives. There are several layers of penalties there.